bagong news online TV ng bagong milenyo. Millennial Online TV, ang katropa mo sa pagbabalita. Nagbabasa ka pa ba ng dyaryo? O nakikinig ka pa ba ng radyo? Kung ngayon, lahat yan ay mapapakinggan nyo na sa inyong mga cellphone. Dahil online na tayo, mga kamilenyo. Kaya manood, makinig dito sa Millennial Online TV.
Rider, sumalpok sa
Kaya
poste ng
i-follow, like, subscribe, at i-share na, mga katropa. Barangay, pangunahing unit ng pamahalaan lokal, kung saan dito pinag-uusapan ang bawat sinalo ng mga residente ng bawat barangay. Dito rin pinag-uusapan ng mga piling halal na opisyal na barangay ang mga proyekto para sa kanilang barangay. Kumustahin natin ang panunungkulan ni Kapitan dito sa Dama Barangay sa Millennial Online TV Worldwide, ang katropa ng bawat barangay.
At tinatapos ang ating pagpupulong. Maraming salamat po sa inyong pagdalo at tapos na po ang ating session. Enjoy na po tayo.
Mga milenyo, pagod ka na ba galing sa trabaho? At gutom na sa maghapong pagtatrabaho, pero wala kang pagkain sa bahay? Narito na ang sagot, mga katropa, ang super manok lechon. Napapawi sa inyong gutom at siguradong mapapa-anirize ka dahil sa tender juicy na jam mo pa, at siguradong malinis at bagong katay buhat sa farm, kaya super masalasa at pangmasa pa. Ano pa hinihintay niyo, mga katropa? Takbo na sa Super Manok Panteño Siniluan at bumili na, baka maabusan ka, katropa. Ikaw ba'y nag-iisa? Nalulungkot? Dahil iniwan at ipinagpalit? Niloko? Nangingilamahal? Kung ngayon, i-type sa inyong mga cellphone, Facebook o YouTube man ang Millennial Online TV. Dahil nasa Millennial Online TV na ang online realista ng bagong milenyo, si Randel Villanos.
Sana'y di magmahal kung dati kung araw nang di pang bata sa piling ni nanay. Nais kong mauli ang awit ninang mahal. You are the one who makes me happy when everything else turns to gray. Walk on through the rain. Walk on through the rain. Though your dreams be tossed and low.
At haharanahin kayo ni Randel ng iba't ibang awitin para maibsan ang inyong inip at kalungkutan kahit nasaan man kayo.
Hanggang sa tumanda. Come on. matanda na, sana'y di tayo magbago.
At pwede rin kayong makiduet kay Randwell tuwing Huwebes ng hapon. Ano pa hinihintay nyo mga kamilenyo? Tawag na!
Iyan ah. Magandang gabi, Pilipinas. Magandang gabi, Luzon, Visayas at Mindanao. Magandang gabi sa iyo, Luz Biminda. Ang oras sa hudyat, alas 7:25 po ng gabi, Philippine Standard Time. At syempre po ngayon ay araw ng Martes, ika-24 ng buwan ng Oktubre, taong 2023. Abay, naku, malapit na talaga. Malapit na talaga ang araw ng Pasko, Paksiw. Isipin nyo, October na, susunod November, sunod December na. Aba, talaga naman wala tayong magagawa. Napakabilis po ng panahon. Yan ay nagbabadya na sinasabi ng malapit na ang ikalawang pagparito. Siyempre, Nino, ng ating Panginoong Hesukristo. Nako, dyan na magkakaalaman. Walang politiko, walang presidente, walang vice-presidente, walang congressman, walang senador, at walang mga mayor o congressman pa man yan pagdating ng ating Panginoong Hesukristo. Diyan magkakaalaman mga kapatid. Okay, magandang gabi po sa inyong lahat. Maulang gabi, Pilipinas, maulang gabi mga katropa, mga kuya, ate, at bunso. At mga kabarangay, nako, kamusta na yung ating pangangampanya? Mukhang yung ating mga politiko ay inulan, pero ika nga, kahit na umulan yan, yung ating mga politiko tuloy pa rin sa kanilang pangangampanya. Dahil sandaling araw na lang ang nalalabi sa kanila, election na. Election fever. Kaya medyo sinasamantala na nila, nilulubos na nila ang pangangampanya sa kanilang mga constituent. Siyempre, nga naman, kailangan puntahan nila yung mga kababayan nila, kababaryo nila. Nga lang, after election, ano na kaya mangyayari? Magagawa pa kaya mag-ikot niya ng mga naupong o mailuluklok o muling nailuklok sa pwesto para mag-ikot at kumustahin ang kanilang mga kabarangay? Iba ho, kapag ka naupo na, wala na, walay na. Huwag mo nang asang iikot siya sa mga residente para mangumusta. Gano'n naman talaga magaling lang talaga pag eleksyon. Siyempre, bago mag-eleksyon, mangangampanya, kamay dito, kamay doon, picture dito, picture doon. Pero after nyan, ay nako, wala na. Walay na, hindi mo na makikita iikot siya mga yan. Meron pa ba akong nakitang ganyan? Wala pa akong nabalitan after na eleksyon nag-ikot siya sa kanyang mga constituents para mangumusta o ano problema. Wala. Siyempre, nakaupo na bahala kayong pumunta sa akin sa barangay. Okay, sa mga kaibigan, ako pa rin ang inyong magiging kasama ngayong gabi. Siyempre dito sa programang Talakayin, Rebisahin, Opinyon, Palawakin, Aksyonan, Tropa. ROCEL Lopez at your service. At mamaya itatampok natin yung lagay ng panahon buhat sa DOST PagAsa. Sa ating pag-uulat ng ating katropang isa sa weather specialist po ng DOST PagAsa, si Ate Grace Castañeda. Mamaya lang po yan. At syempre, kasunod niyan, itutungay natin sa inyo yung ginagawang pagdinig ng Senado dyan po sa ating maritime. Ano na ba ang lagay? Kamusta na ba ang investigasyon ng ating Senado? At yan ay pinangunahan po ni Senator Continuation ni Attorney o Senator Francis Tolentino. Alam nyo, may mga nangyayaring aberya kasi sa maritime, sa ating marina, sa mga Coast Guard, sa ating mga pantalan na medyo hindi ho nababalita. Ngayon ito ay talagang ang Senado ho ngayon talaga naman na pinakikita, tinetelevise kay mga social media ang nangyayari po sa ating kapaligiran, sa ating gobyerno. Yung mga problema katulad ni Senyor Aguila, di ba? Ngayon lang pumutok yan dahil binibigyan ng pansin ng Senado yung mga reklamo, no? Kahit maging sa Kongreso, talagang pinibigyan nila ng pansin para nalalaman ng ating mga kababayan. Dapat naman, di ba? So yan talagang dapat na ginagawa ng ating mga mambabatas. Hindi lamang sa puro paggawa ng batas, kundi yung ultimo problema ng ating sambayanan ay dapat inaalam nila. Okay, so mga kaibigan, huwag na natin patagalin. Sa oras na alas 7:30 po ng gabi Philippine Standard Time, abay alamin na natin po sa DOST PagAsa ang lagay po ng ating panahon sa pag-uulat ng ating kasamang si Ate Grace Castañeda. Nandito po.
Magandang umaga sa ating lahat. Ngayon ay October 24, 2023 at narito ang update ukol sa maging lagay ng panahon sa susunod na 24 oras. Patuloy pa rin umiiral ang northeast monsoon o amihan dito sa bahagi ng Northern Luzon, kung saan ngayong araw dala pa rin ito yung maulap na kalangitan at mga pag-ulan sa bahagi yan ng extreme Northern Luzon. Samantala, ang shearline naman ay patuloy pa rin nakakaapekto dito sa may silangang bahagi ng Central at Southern Luzon, kung saan meron pa rin itong dalang maulap na kalangitan at mataas na tsansa ng mga pag-ulan, pagkilat at pagkulog dito yan sa silangang bahagi ng Luzon. So pag-iingat pa rin para sa ating mga kababayan sa posibilidad ng mga pagbaha at pagguho ng lupa. Samantala, sa nalalabing bahagi naman ng ating bansa ay generally fair weather condition yung ating mararanasan. Maliban na lamang yan sa mga tsansa pa rin ng may hinang pag-ulan or pag-ambon sa nalalabing bahagi pa ng Northern Luzon, maging sa mga tsansa ng mga isolated rain showers or thunderstorms sa nalalabing bahagi pa ng ating bansa. At sa kasalukuyan ay wala rin tayong minomonitor or namamataan pa na sama ng panahon na maaaring makaapekto dito sa ating bansa. At para nga sa magiging lagay ng panahon ngayong araw ng Martes, maulap na kalangitan at mga pagulan ng mararanasan dulot ng amihan dito sa bahagi ng Batanes at Babuyan Island. Samantala, meron pa rin tayong mga kalat-kalat na pagulan, pagkidlat at pagkulog na mararanasan dito yan sa bahagi ng mainland Cagayan, Isabela, Quirino, Nueva Vizcaya, Aurora, Quezon, maging sa mga probinsya din ng Camarines Norte at Camarines Sur, dulot yan ng amihan ng shearline. So muli po, pag-iingat para sa ating mga kababayan sa posibilidad ng mga pagbaha at pagguho ng lupa. Samantala, sa nalalabing bahagi ng Luzon ay magiging bahagyang maulap hanggang maulap yung kalangitan or generally fair weather condition yung ating mararanasan. Maliban na lamang yan sa mga tsansa pa rin ng mga mahihinang pag-ulan or pag-ambon, dito yan sa bahagi ng Cordillera Administrative Region at dito sa bahagi din ng Ilocos Region, dulot yan ng amihan. Samantala, meron din tayong tsansa ng mga biglaang pag-ulan, pagkilat at pagkulog, dito naman yan sa Metro Manila, maging sa nalalabing bahagi pa ng Luzon, dulot naman yan ng mga localized thunderstorms. Agwat ng temperatura dito sa Metro Manila ay mula 23 to 30 degrees Celsius. Samantala sa bahagi naman ng Visayas at Mindanao, ang buong bahagi ng Visayas at Mindanao ngayong araw ay makakaranas pa rin ng bahagyang maulap hanggang sa maulap na kalangitan or generally fair weather condition pa rin yung ating mararanasan. Maliban na lamang yan sa mga tsansa pa rin ng mga isolated na mga pag-ulan, pagkilat at pagkulog, dulot yan ng mga localized thunderstorms. And during severe thunderstorms, ito po mga pag-ulan nito ay posible pa rin maging katamtaman hanggang sa mga malalakas na pag-ulan na maaaring magdulot ng pagbaha at pagguho ng lupa. So pag-iingat pa rin po para sa ating mga kababayan. Agwat ang temperatura dito sa Cebu ay mula 25 to 31 degrees Celsius at sa Davao naman ay 24 to 34 degrees Celsius. At para naman sa lagay ng dagat baybayin ng ating bansa, wala tayo nakataas na gale warning kaya malaya makapalaot yung mga kababayan nating mangingisda, pati na rin yung may mga maliliit na sasakyang pandagat. Ngunit iba yung pag-iingat pa rin po para sa mga maglalayag dito sa bahagi ng Northern Luzon kung saan magiging kataptaman hanggang sa maalon yung lagay ng ating karagatan. At para naman sa 3-day outlook ng mga key cities ng ating bansa, malaking bahagi ng ating bansa ay patuloy pa rin makakaranas ng bahagyang maulap hanggang sa maulap na kalangitan or generally fair weather condition kung saan dito sa Metro Manila bukas ng Miyerkules at Huwebes ay meron lamang tayong mararanasan ng mga isolated na mga pag-ulan, pagkilat at pagkulog dulot yan ng mga localized thunderstorm. And by Friday naman ay makakaranas lamang tayo ng mga may hinang pag-ulan or pag-ambon at magiging mas malamig din yung panahon na ating mararanasan, lalong-lalo na yan sa madaling araw dulot po yan ng amihan. Agwat ng temperatura dito sa Metro Manila ay mula 23 to 31 degrees Celsius. Samantala, sa bahagi naman ng Baguio City, the next 3 days ay patuloy ngang mas malamig na yung panahon na ating mararanasan at meron pa rin tayong tsansa ng mga may hinang pag-ulan or pag-ambon, dulot pa rin po yan ng amihan. Agwat ng temperatura sa Baguio City ay mula 16 to 23 degrees Celsius. At sa bahagi naman ng Legazpi City, Metro Cebu at Metro Davao in the next 3 days ay makakaranas tayo ng bahagyang maulap hanggang sa maulap na kalangitan at meron tayong mga posibilidad pa din ng mga isolated na mga pag-ulan, pagkilat at pagkulog dulot yan ng mga localized thunderstorms. Muli po, during severe thunderstorms, itong mga pag-ulan nito ay posible pa rin maging katamtaman hanggang sa mga malalakas na pag-ulan na maaaring magdulot ng mga pagbaha at pagguho ng lupa. So pag-iingat pa rin po para sa ating mga kababayan. Agwat ang temperatura sa Legazpi City ay mula 24 to 32 degrees Celsius. Sa Metro Cebu ay 25 to 32 at sa Metro Davao naman ay 24 to 34 degrees Celsius. Dito sa Metro Manila, ang araw ay sisikat mamayang 5:49 ng umaga at lulubog mamayang 5:32 ng hapon. Patuloy po tayo magantabay sa updates na ipapalabas ng PagAsa at para sa mas kumpletong impormasyon, bisitahin ang aming website pagasa.dost.gov.ph. At yan po muna ang latest dito sa Weather Forecasting Center ng PagAsa. Grace Castañeda, magandang umaga po.
Ayun, maraming salamat sa iyo kasamang Grace Castañeda. At nagatid po yan sa atin sa oras na alas 7:36 po ng gabi, Philippine Standard Time. At syempre tuloy-tuloy pa rin tayo sa ating programang Tropa. At bago tayo magpatuloy mga kapatid, mga kaibigan, abay magandang gabi po sa aking kumpare na nanonood ngayon. Nakita ko sa aking monitor si Paring Bayani o Bayan Jogrades ng lalawigan ng Bulacan. Pero ngayon mukhang nasa Region 1 yata siya. Nasaan ka ba ngayon, Paring Bayan? Okay, naku mga kaibigan, na talagang maulan. Ingat po sa ating mga kababayan. At yun nga, tulad na sinasabi natin lagi pa rin magdala ng mga panangga sa ulan. Tulad ng jacket, payong, sweater, kung anong pwedeng panangga sa ulan. Para kung sakaling biglang bumusang malakas na ulan, hindi tayo magmumukhang basang sisiw. At yung mga rider, mga motor riders natin, mga motorcycle riders, ingat po. Huwag yung kung biglang umulan, hahatawin nyo ang takbo, no? Huwag po, mas delikado. Ibali na ho kayo mabasa ng konti, basta maitabi nyo ng maayos, na maingat, dapat ho ganun. Alalahanin nyo, slippery when wet. At syempre, delikado po sa dalawang gulong, ang masyadong matulin, tas biglang mamembreno, naku po, ang dami hong sumesemplang sa ganyan. At kung misa, hindi masasabi na pag sumemplang ka, may mga dumadang malalaking sasakyan na daanan ka, o edi, paktay ka na. Okay, sa mga kaibigan, at wag na natin patagalin, no, dahil talaga tayo po'y nagmamadali, dahil gabi na rin po, panoorin po natin yung pong ginagawang pagdinig ng Senado dyan po sa ating maritime, no? Alam nyo, ang dahil nagiging problema na hindi natin nalalaman tulad na sa mga Philippine Coast Guard, sa Marina. At least ito, nandiyan na po ngayon na Senado na talaga namang ito'y kanilang binibigyan ng pansin. No? Dahil yung ating mga kababayan din ang nakasalalay, particular nga yung mga nakapwesto sa gobyerno. So ito'y pinangunahan po ng chairman ng committee na si Chairman Francis Tolentino. Pwede kayo magbigay ng inyong opinion at kung anong inyong pwedeng i-suggest, pwede natin iparating sa kinauukulan. Panoorin po natin. Particular na yung mga nakapwesto sa gobyerno. So ito yung pinangunahan po ng chairman ng committee na si Chairman Francis.
since this is just a continuation of a suspended hearing, there is no need for an appropriate quorum here. We'd like to recognize the resource persons present here. Secretary, can you acknowledge them again for the record,
Yes, Mr. Chairman.
including those virtually present?
Yes, Mr. Chairman. Good afternoon, everybody. Representing the Department of National Defense, we have Mr. Jesse M. Pascasio, Executive Assistant under the Office of the Undersecretary for Strategic Assessment and Planning. We also have physically present with us is Solicitor General Menardo I. Guevara. Afternoon, sir. Representing the National Security Council, we have National Security Specialist 4, Ms. Donalyn M. Dolina. We also have Deputy Director General Nestor C. Jerico. From the National Intelligence Coordinating Agency, we have Deputy Director General Restituto Santos. Afternoon, sir. From the Philippine Navy, we have Rear Admiral Cesar Bernard N. Valencia.
Good afternoon, sir.
From the Philippine Coast Guard, we have Captain Nelson J. Timbang.
Good afternoon, sir.
Coast Guard Captain Donet Dolina.
Good afternoon, sir.
And Coast Guard Commander J.T. Tariela.
Good afternoon, sir.
From the University of the Philippines Institute for Maritime Affairs and Law of the Sea, we have Attorney J. Batong Bakal.
Good afternoon, sir.
With him is Attorney Neil Simon S. Silva. Attending virtually also from the same institute is Attorney Jacqueline Espinilla. Attending virtually with us from the Australian National Centre on Ocean Resources and Security, Dr. Stuart K.
Good afternoon.
Good afternoon, Professor.
That is all, Your Honor. Thank you.
Thank you. Before we discuss lengthily the bills under consideration, and we have 1, 2, 3, 4, 5, 6, 7, 8 pending measures on the proposed Maritime Zones Act. May I get a 2-minute statement coming from the Philippine Coast Guard to satisfy the curiosity of our viewers and listeners as well? What is the relevance of the pending measures with the incident that transpired yesterday? Will it help? Will it clarify? Will it dilute the confusion? Will it foster more amicable situation insofar as the Coast Guard is concerned? Anybody from the Coast Guard? Yun nangyari kahapon?
Thank you, Mr. Chair. On the part of the Philippine Coast Guard, sir, I think the passage of the maritime zones would help the Philippine Coast Guard as a law enforcement agency and the armed forces of the Philippines in clearly identifying the maritime zones of the Philippines. With respect with the incident that happened in Ayungin Shoal, which falls within the exclusive economic zone of our country, I think the passage of a maritime zone would clearly strengthen our defined zones in our maritime jurisdiction, sir.
Will it enable other states to follow international norms and standards as a form of an obligation under existing international customary laws? Will it enable them to adhere? Will it force them to follow if we pass this maritime zone law? Will it force adherence and compliance, making it obligatory for them to respect not just our territory but maritime safety as well?
Mr. Chair, I would like to believe that the countries in the region and other claimant states in the South China Sea, which all of them are signatory to the United Nations Convention of the Law of the Sea, are in the obligation to respect our maritime jurisdiction if ever we're going to define our maritime zones. But of course, that's a belief that we would like to carry on. But obviously, there are some states who would choose not to respect the provisions of the international law, particularly the UNCLOS. So I don't want to be that pessimistic to argue that all of the countries would respect our maritime zones, even if we're going to pass our own maritime zone, sir.
Thank you, Coast Guard. Can we have another opinion just to edify this committee coming from the Office of the Solicitor General? If this law is passed, would it, in the same question, it's like the final question in a beauty pageant, the same question is being asked. You just covered the ears of the finalists to really vet the correct answer. But here, everybody's listening. Kung maipapasa po ba itong batas na ito, ay mababawasan yung tensyon sa West Philippine Sea?
Good afternoon,
Good afternoon,
Senator
Roger.
Tolentino. Based on my reading of the proposed bills on the Philippine maritime zones, immediately it occurs to me that this is essentially a reflection of the relevant provisions of the UNCLOS, to which more than 100 countries are members. And therefore, if we have a law like this, which is essentially a reflection of an international convention where the members comprise practically the entire international community, there is an expectation, Mr. Chairperson, Senator Tolentino, of an obligation on the part of these member states to comply with our own laws, since these are, as I said, a reflection, essentially, of an international convention of which they are members.
So what you're saying, Solicitor General, is that if this bill is passed into a law, we would be expecting other state signatories to UNCLOS to respect the same.
That is very true, because this will be our domestic version of an international agreement. And these are the laws of the coastal state. And therefore, all flag states with vessels plying, for example, our maritime waters, would have also a duty to comply with the laws enacted by the coastal state, like the Philippines.
Thank you. And perhaps you would just consider it very coincidental that we scheduled the hearing not knowing in advance that an incident would happen yesterday. Thank you. Having heard those statements, I think it is more proper for us to really tackle the bill, all the bills, including the controversial provisions, provision by provision, para po madali po itong matapos. Ang nakikita ko lang pong contentious provisions would be those reflective of the definition of archipelagic waters, the provision on reciprocity, the provision on exclusive economic zone, and that's about it. That's about it. Unless others would be in a contrary position. So this is what we are going to do. We will be asking the opinion, not just the official position papers of the resource persons present here, but their preferred hubris of how the law should be shaped. So we will be asking these are more legal and academic. So perhaps if the resource persons present here physically would allow, we will be asking first our resource person who is out of the country. Isa lang siya, no? Isa lang siya, Professor K. Just one question, and I think you gave a different opinion concerning, you raised three matters. You raised you raised an issue concerning I know, I think it is Professor Beckman. Professor K, were you the one who raised the issue concerning reciprocity?
Yes, Your Honour, I did.
Yes. So your contention is that the provision on reciprocity should not be included in the measure. Is that correct?
Certainly, Senator. I would take the view that the strength the Philippines draws in being able to respond to other states in the manner that the Coast Guard and the Honourable Solicitor General have mentioned is the consistency of the legislation with international law. Reciprocity invites a different approach where you would be saying, well, if there is a breach by somebody, then we reserve the right to provide for a similar breach. And I'd caution against that. I think the strength the Philippines has had in its dealings with other states, the support that it received from other states in the wake of the famous arbitration that you had, stemmed from the Philippines' compliance with international law. I know that other viewpoints were raised, and certainly there was one suggested by my friend and colleague, Professor Batong Bakal, saying perhaps this would be a matter that the legislation could reserve to the President to determine. Not being a constitutional lawyer or admitted in the Philippines, I'm happy to defer to his suggestion in this regard. But I do think that the Philippines draws great strength from its consistency with norms of international law, and the reciprocity provision would potentially undermine that objective. I'm sorry, I've lost all sound at this end. And so if there was a question directed to me, I apologise, Senator. I didn't hear any of it at all. I'm sorry, I have no sound.
Briefing is resumed. Thank you. My question is reciprocity now a recognized principle as part of customary international law? To your knowledge, Professor.
Certainly, Senator, the concept of reciprocity exists principally in a trade context. It isn't unknown in international law. I'm not sure that it would assist, as I say, in the Philippines' efforts to draw international support, which was the thrust. I'm not suggesting that reciprocity itself is unknown, but only that it would be a measure that would not assist in drawing additional support to the Philippines and its international legal position.
What I'm referring to, Professor, broadly is the concept of reciprocity that probably would encompass international trade, diplomatic privileges and immunities, human rights, extradition, etc., etc. So is this a well-accepted concept?
Yes, certainly, Senator. Reciprocity does exist.
Yes. Go ahead.
It involves basically responding to a breach by denying some privilege to the other side, which, if it was done independently, would amount to a breach itself. This is why the concept effectively is a breach for breach, which is why I wouldn't encourage it, because the Philippines' strength has been through close compliance with the law of the sea.
So, but if it is not breach for breach, it is not similar to your an eye for an eye. So but what is needed under international law is that it has to be commensurate to a wrongdoing. Correct?
That's correct.
Correct.
And
So,
certainly that's the context in particularly international trade law where the concept is most commonly used.
it has to be proportionate to the wrongdoing done by another state. Is that correct?
Absolutely. That's correct.
So the question now here is, do we need to legislate reciprocity? If it is a well-accepted principle under international law.
I wouldn't like to speak to constitutionally how these arrangements go. I know that in responding to this issue, Professor Batong Bakal suggested that this would be a matter that the President would have the power to deal with. If that's so, then legislation specifically dealing with the matter wouldn't be necessary if it's part of the President's executive functions.
So what you're saying is that perhaps because it operates as an underlying principle or a customary practice in international relations, there is no need for domestic legislation. For instance, if a state would not issue a visa to a citizen of another country, that other country can also refuse to issue a visa to that other state, refusing to issue a visa to its own national. Is that correct?
Yes, that's correct, although the refusal to issue a visa wouldn't itself be a breach of international law.
Yes, that's right. But what I'm saying is this. There are certain international norms and practices that need not be legislated.
Certainly, that would be a perfectly reasonable proposition.
And would you say that the maritime zone bills section, I think do you have a copy, sir, of the proposed measure? I'm holding a copy here of a measure which was approved by the House. The rights and privilege, I'm reading it now, section 12. The rights and privileges of foreign vessels and aircrafts in the Philippine maritime zones declared herein are recognized under conditions of reciprocity and mutual respect. Do we have to legislate mutual respect?
I don't believe so, Senator. No, I wouldn't think it was necessary.
There was an issue raised by the Department of Justice concerning countermeasures. Countermeasures, perhaps the representative from the Department of Justice can can refresh our memory. What was that again, ma'am?
Yes, good afternoon, Mr. Chair and everyone. During our last meeting, I did mention about countermeasures in relation to this concept of reciprocity in Section 12 of our pending Senate bills. And this is already what you are discussing, Mr. Chair, with Professor Stuart K. It's that when a state endures or acts inconsistently with international law, thereby injuring your rights, you can take action. Because you have been injured, you can take action against that other state. And this is in relation to the nature of the international legal system, wherein there is no court with compulsory jurisdiction and there is no world police. So if there's no court with compulsory jurisdiction and no world police, then how can you get remedy, Mr. Chair, if you have been injured by another state? So you can take countermeasure. First, you can demand that the other state stop the action, the illegal action that it is doing. If it doesn't stop, then you can take countermeasure against that other state. And your countermeasure, of course, must be proportionate with the injury or with the action that caused the injury to you, and your own countermeasure must not involve the use of force, because use of force is not allowed under international law. So that's it, Mr. Chair. Countermeasure: if you are injured, then you can take action also against another state that injured your rights as provided by international law.
The position of the Department of Justice that we should include reciprocity because there is a need for countermeasure. There is a need. There is a need for flexibility on the part of the executive branch to impose countermeasures.
Yes, that's correct, Mr. Chair. Even without this provision, I stated during our hearings 2 hearings ago that even without this provision, Mr. Chair, the President, as part of his foreign relation powers, can actually take countermeasures. But we defer to the wisdom of the body if Congress would also like to provide a statement in its own law as a form of lawfare, wherein that if another state is committing an action inconsistently with UNCLOS, thereby injuring your rights, don't you have the right to take action against that other state as a form of countermeasure, so long as that countermeasure does not involve the use of force? You're allowed that, Mr. Chair, under international law. So it's a congressional statement in its own law. The President, without this provision, can take countermeasures. But if the Congress would also like to have a statement in their own law of that particular principle, it's not illegal, Mr. Chair.
So what you're saying, Attorney Ganchon, is that there is no need to explicitly include Section 12 because a countermeasure, the ability to respond, can be understood as a general manifestation of one's sovereignty. There is an inherent and supreme authority recognized by international law for a state or country to take control over its territory, population, to effectively govern. And there is no need for the President to be granted that power because the President has that power. That power is part of the functions of the President in the exercise of his executive functions, protecting the sovereignty of the country. Correct? Madam.
Yes, I agree with what you've stated, Mr. Chair. Let us imagine the international community. All members of the international community are sovereign states. All are equals. If one equal committed a wrongful act against you, since all of you are equal, wouldn't you be able to have the right to also take countermeasure against that other state? So, Without this provision, yes, the president can take countermeasures. But if Congress would also like to have its own statement on reciprocity and countermeasures, it can do so. It's not illegal. If you remember, Mr. Chair, during our first hearing, Professor K mentioned that it's actually a question of implementation. It might be difficult to implement. No? If you have a vessel there of a state, and you need to determine first if the flag state of that vessel has previously committed an act inconsistent with international law. Because if you take a look at Section 12, it says that the flag state of that vessel must, if the flag state of that vessel acted inconsistently with UNCLOS, so it's not just an action inconsistent with general international law, it should be an action that is inconsistent with UNCLOS. We all know, the one thing that we're not talking here is, we all know who this state is, acting inconsistently with UNCLOS. We all know who this state is. It's not any other state, actually. No? When I believe when this provision was drafted, we're thinking of a particular state acting inconsistently with UNCLOS. So I think that's the reason behind this provision, Mr. Chair. But if you take this out, it's okay. But actually, it can also be placed, Mr. Chair, in the archipelagic sea lanes law. Because actually what we are concerned of is the passage of foreign warships in archipelagic waters by warships of foreign states that are acting inconsistently with UNCLOS, especially in the West Philippine Sea. So we don't like the vessels or warships of this foreign state acting inconsistently with UNCLOS to pass through our archipelagic waters. So if you don't place it here, you can place it in the archipelagic sea lanes law, or you can totally take it out, Mr. Chair. All three options are legal, Mr. Chair. There's nothing illegal with retaining it, removing it, or transferring it to another law. If we retain it here, Mr. Chair, we just need to revise it to take into consideration the comments that we have received so far from our experts, local and foreign, Mr. Chair. Thank you, Mr. Chair.
Thank you, Attorney. Professor K, from the discussions right now, what is probably the point of convergence is this: a countermeasure is needed to provide a sort of self-help for wrongful acts made by another state to induce the responsible state for that wrongful act to cease the wrongful act and to go back into the state of compliance. And the recent incident yesterday probably would illustrate this. Our Coast Guard was hit by a Chinese militia vessel. Our resupply ship was hit on the port side by a Chinese Coast Guard vessel. So in terms of countermeasures, the international law would not espouse the use of force, but would support the notion of commensurate, proportional countermeasures. We're now skipping a bit Section 12 without putting you into a controversial position. What countermeasures would you probably suggest that should be done? Would it be a diplomatic countermeasure? Would it be an economic measure? Could it be some trade restriction? Among others. Professor K, we are listening.
Certainly, Senator, there'd be a range of responses. I would think that diplomatic would be the one that the Philippines has enjoyed some success with in recent years, and quite a number of states have been happy to stand with the Philippines in responding to incidents, as well as statements that have been made that have been at variance with international law. So to that extent, I think it would be good. Certainly, international law does not permit the arrest of vessels which are sovereign immune. So if a Coast Guard vessel undertakes behaviour that's inconsistent with your law, international law will not permit you to arrest that vessel because of the nature of the vessel itself. And this was reaffirmed relatively recently in a case between Argentina and Ghana, where the Ghanaian Supreme Court ordered the arrest of an Argentinian naval training ship. So a response that involves arrest or of that nature would not be possible. It would be a very significant breach of international law. But diplomatic and potentially other restrictions in terms of refusing to issue visas or responses of that nature are certainly within the power of the Philippines to do, and might be effective in expressing your concern as to the unacceptable nature of behaviours like those that I've read of that have happened in the last 24 hours.
Thank you, Professor. Attorney Batumbakal, any words of wisdom?
Yes, Your Honor. Thank you for this
We're
opportunity.
referring now to Section 12
Yes, Your Honor.
in relation to what happened yesterday.
Yes, Your Honor. The provision on reciprocity and mutual respect is actually one that I've advocated, and I was the one who actually introduced the original draft of this. And the reason for this is, well, actually it's more for domestic purposes, really, national purposes, because one thing that we have noticed, even within the national context, is that people often tend to need a specific reference in law, a specific provision, a specific textual basis to justify actions, especially if such actions might be controversial. And that is the concern here with respect to the maritime zone law, is that we are actually complying with our obligations under UNCLOS, but certain states will not and can abuse it. For example, the state that Attorney Ganchon is referring to is of particular interest because I can think of two possibilities already. One is that they will, for example, invoke the right of archipelagic sea lanes passage through archipelagic waters when they pass through Philippine waters. But as soon as we try to pass through waters that they claim to be theirs, they will say that, no, you cannot pass through these waters, and particularly we're referring to naval vessels, military vessels. And that would be an abuse, basically, of the rights and privileges that we recognize that they have in our waters, but they will not reciprocally recognize our rights in their waters. The other one is with respect to baselines. Okay, we have established archipelagic baselines. These are in accordance with international law, with UNCLOS, but they also don't necessarily come with some burdens because that's the result of the compromise we agreed to. That compromise requires other states to also respect our rights to establish such baselines and to act in accordance with our laws. But this other country has established its own baselines, which they are now trying to project as archipelagic also, but they claim rights within those waters in excess of what UNCLOS allows. And they would try to establish these baselines around the island groups that they claim in the South China Sea. The Spratly Islands, for example, they will claim that those are internal waters, not archipelagic waters, notwithstanding the fact that they are trying to present them supposedly as archipelagic baselines. So that is another way by which they will abuse these concepts. And I do not want, basically, our government in the future to be somewhat hesitant, no? Because we know that this other state will say that, look, your own law does not allow you, does not say anything about you taking such actions against states which exercise their rights and privileges under UNCLOS. So I do not want a situation where our own laws will be used against us simply by the mere silence of those provisions. So this particular provision is actually declaratory as well as much as providing options. Mutuality and mutual respect are basic concepts even in contract law. And that is, especially in a situation where you have an international community where, as Attorney Ganchon mentioned, no, there is no third party that can enforce or no third party with power over the sovereign state. It really depends on, in a way, self-restraint of all states. Self-restraint in that they will follow what it is that they agreed upon. And we have a problem with a state which does not follow what it has agreed upon. So I would want to emphasize that, no? That particular prevention of reciprocity and mutual respect as a kind of declaration. No? And then the second part is the one that reserves the right of action to the executive very clearly. It will provide the executive in the future a clear legislative mandate and basis to take action if it is necessary. No? It is still subject to their discretion after all, but the statement of that reservation of that power, I think, is very important to ensure that the intention of this Congress in enacting this maritime zone law is not, is not subject to some kind of loophole or gap due to silence on certain matters. So that is really why I put it there, Mr. Chair. The other concern that I have is with respect to our exclusive economic zone in continental shelf, where we have every right to explore and exploit for petroleum resources, and due to the looming energy shortage.
Before we proceed with the other sections,
yes, sir.
Perhaps I'll be asking Professor K and Attorney Ganchon again. Your preference a while ago was, Attorney Ganchon, was to have this placed in the archipelagic sea lanes law. Is that correct?
Just one of the options,
One
Mr.
of the
Chair, because the
options.
department actually defers to the wisdom of Congress. The department says you have these options.
Yes.
You can retain. But if you retain it, you revise it based on the comments here by our experts, local and foreign, or you can delete it, or you can transfer it to the archipelagic sea lanes law. But of course, if you transfer it, Mr. Chair, to the archipelagic sea lanes law, it would be limited only to violation of UNCLOS committed in our archipelagic waters. Here, it's a violation of UNCLOS with respect to our maritime zones, all of our maritime zones, territorial sea, contiguous zone, exclusive economic zone, and continental shelves. In such a way, it's a broader provision, Mr. Chair. So all of those options one can take, and we defer, Mr. Chair, to the wisdom of Congress. If, as stated by Professor J. Batong Bakal, if you want to also include in your law a statement that the President can actually take this action, okay, you can do so, Mr. Chair, because Professor J said a mere silence in the law might...
Isn't it the non-mention of the presidential powers would not necessitate the defanging, the diminution of the powers of the presidency? Kanya naman talaga yung powers na yun eh. By mentioning the powers, would it actually restrain? Because you're now putting a parameter, because that's his power as the chief architect of foreign affairs, as the commander-in-chief. That's part of his array and menu of powers. So do we have to enumerate all the powers that the president has at his disposal? Certainly not. So he has the diplomatic tools, all part of his toolkit, diplomatic, economic, military, etc., etc. It's all there for his own use. Perhaps, Professor K, can you elaborate further on the hardship that probably would be felt during the operationalization of this provision? Is it administratively hard for the government to implement this? There was a mention before, which I forgot, about the difficulty in making this operational. There is reciprocity provision. You have the floor.
Thank you, Senator. Look, the provisions that were featured in a number of the bills indicated that reciprocity was possible where another state provided for breach. That suggested to me that there might be a requirement to assess where breaches existed in order that the executive could frame what reciprocity might include, and that could be quite onerous as well. If it's based around the flag of a vessel, that can be undermined by other vessels being utilised. So, for example, a state may not flag a vessel, but may have beneficial ownership in the vessel or control of it, or it might be controlled by nationals of that particular state, in which case they could avoid the nature of the provision. My own country has had problems with this in the past where vessels have been flagged in places such as Tuvalu, but they're under the direct control of the government of North Korea. And in those circumstances, a provision that was directed towards flag wouldn't have any meaningful effect because Tuvalu isn't the problem in this instance. It's the North Koreans directing what the vessel did. In these circumstances, I'd counsel towards giving the executive the ability to be able to measure what might be an appropriate response, because then it can be tailored to a particular issue and measured against that issue, as opposed to something that might have a potentially wider ambit if expressed in legislation. And that was the point I was trying to draw out with my initial comments at the hearing before last that I attended.
So the underlying principle is to give the president that great flexibility in responding to a situation without being limited by a specific provision, because the buzzword that you just mentioned would quote unquote is onerous. It's similar to our tax code here in the Philippines and even the Federal Internal Revenue Code of the United States, wherein the Commissioner of Internal Revenue is given that broad power to change some rates, tariff rates, etc., etc. So, are you saying that the president has that power, and that the president the presidential power should not be limited by a specific provision because he has that broad power and should be given enough elbow room to respond? Is that the correct rationale for this?
Essentially, Senator, yes, although I must stress that I'm not a constitutional lawyer qualified in the Philippines, but you've expressed my concern quite neatly.
Solicitor General, any word on this, sir?
Mr. Chair, we're still on the topic of reciprocity.
Yes, Section 12.
Mr. Chair, the matters of reciprocity and what was mentioned earlier on countermeasures seem to me to be very related to each other. To me, it seems that reciprocity will be more on the positive side and countermeasures on the negative side. So we're talking about reciprocity in the sense that if certain states are not granting the privileges that we are extending to them, then we have the right to deprive them of the same privileges. So it's mutuality. And I think that is an accepted principle under international law. So it's just a matter of, it's something for the Congress to really decide on whether to include something like that or not in the maritime zone bills. But I do not see any disadvantage if we have something like that. A provision, a general provision on reciprocity and mutual respect. However, on the negative side of putting a provision on countermeasures, as you correctly pointed out, this is something that the executive, the chief executive, can actually perform because this is the nature of executive power. So I'd rather not have something like that in the draft bill, but have a provision, a general provision on reciprocity and mutual respect.
Thank you. Perhaps we can jump on to the two other concerns. The definition of archipelagic waters. This probably would be a provision that would have to be discussed lengthily, as well as the implications of the 2016 arbitral ruling. May we ask again the statements coming from Professor Batumbacal? Do we have the same bill in front of us? I have here the approved House bill. (7819). if I can go ahead, archipelagic waters is defined under Section 5 of the measures approved by the House. So, within the paragraph 2, within the archipelagic waters, closing lines for the delineation of internal waters shall be drawn pursuant to Article 50 of the UNCLOS and other existing laws and treaties. Thereafter, the Philippines exercises sovereignty and jurisdiction over its archipelagic waters and airspace, over it as well as its seabed and subsoil in accordance with the UNCLOS and other existing laws and treaties. Professor Batang.
Yes, Your Honor. This, I think, is the most compact way in which we can legislate essentially the implementation of Part 4 of UNCLOS, which is comprised of many more articles. So this is really a general statement that allows us to do so, Your Honor.
What about the implications of the arbitral ruling? Should we make any reference or explicitly include the 2016 arbitral rulings implications on the archipelagic waters?
Well, Your Honor,
reference.
well, with respect to the South China Sea Arbitration Award, there is already a general reference to it that covers the entire bill. So I do not see really any need to restate it here. Also, the South China Sea Arbitration Award, most of it really concerns the exclusive economic zone and continental shelf outside of the archipelagic waters. So they would be much more relevant with respect to the EEZ and continental shelf provisions. And I think that's why we did not have to do it here in the archipelagic waters provisions.
Response concerning Article 5.
Thank you, Mr. Chair. Yes,
Do we have the same bill?
yes,
in front of us? Yes.
yes. You're looking at the House bill, Mr. Chair. Yes, and in fact, your own bill, Mr. Chair, is identical to this House bill. So, with respect to archipelagic waters, the language here is consistent with the pertinent provisions of UNCLOS, Mr. Chair. We don't need to make a statement in Section 5 with respect to the arbitral award, because the arbitral award actually did not really tackle archipelagic waters. Well, it did mention about archipelagic baselines around Spratly Islands, but it did not really rule on archipelagic waters. It ruled on our exclusive economic zone in the West Philippine Sea, that we have an exclusive economic zone there, and that the 9-dash line of China, which encroaches on our exclusive economic zone, is a blatant violation of UNCLOS and international law. And Mr. Chair, if you take a look at Section 10 of this bill, Mr. Chair, which is also identical to your Senate bill, the arbitral award is already mentioned in Section 10 entitled Adherence to Existing Laws. So there's a statement there that the other rights of the Philippines relative to its maritime zones and entitlements shall be exercised in accordance with UNCLOS. The awards rendered by the arbitral tribunal in the Permanent Court of Arbitration case number 2013-19 in the matter of the South China Sea arbitration between the Republic of the Philippines and the People's Republic of China.
Do we really have to throw this question back? I'm sorry. Do we really have to insert the name of the parties here, or do we just cite the case itself? Because it might, if we legislate the title of the case, the citation, it probably would years from now connote a different or promote a different branch of history. What I'm saying is, looking forward, perhaps the goal of international law is to really promote friendship and amity. But if you really would carve out any reference to an opposing party here, would it promote enduring, lasting F, or do we really need to have that scar? We will win. We have won Do we really want to have that scar as part of our legislation?
Mr. Chair, it's a matter of style, Mr. Chair, but this is, I confirm that this is the correct full name of the case. If you take a look at page 1 of that case, Mr. Chair, this is the full name in the matter.
We will not try
of
to
the
revise
South China
history
Sea
years ahead, but
arbitration.
what we're framing right now is that, that the Solicitor General mentioned the word positive. Would it be a positive legal term to include? It's a matter of style, I agree.
It's a matter of style. You can say 2016 South China Sea Arbitral Award, Mr. Chair. And in fact, Mr. Chair, we noted in our study of this bill that it says awards, no? It's plural, because there's actually 2 awards issued by the Arbitral Tribunal. The first award is the award on jurisdiction and admissibility issued on October 29, 2015, and the second one is the award on the merits issued on July 12, 2016. So if you want to be very accurate and if you want to refer to awards, then you need to insert here the date October 29, 2015, because that's the first award issued by the tribunal.
And who knows, there might be other awards.
Yes, but it would not be the same PCA case number 2013-19. Might not be the same, Mr. Chair. So we're just referring here to PCA case number 2013-19, and there are 2 awards issued by the tribunal under this PCA case number, Mr. Chair.
Thank you. A matter of style, perhaps. Solicitor General, I saw you nodding your head or shaking your head. Matter of style as to
Yeah, it's a matter of style.
Section 10, but
Yeah, it's a matter of style.
really we're on archipelagic waters, so reference was made to Section 10, but perhaps I skipped this, the Section 2 definition of maritime zones would probably need more refinement insofar as phraseology would be concerned. So Section 2 has no reference to our Constitution. Section 2 has no reference to UNCLOS. Section 2 has no reference to baselines. Professor Batumbakal, can you enlighten us on this?
Yes, Your Honor. Yes, I think this again, Section 2 was an attempt to encapsulate the coverage really of the Philippines, national territories and maritime zones. No, so that is, I think that's the reason for the economical nature of the provisions. No, but I recognize you're correct, Mr. Chair, that mention of the Constitution, UNCLOS, and the different categories of the Philippine national territory under Constitution are not there. So if the chair would indulge, I did come up with a possible more detailed formulation that covers the chair's concerns.
Professor, you can submit that to the committee, but you can,
Yes, sir.
you can read the portion of that, because what we're crafting is a maritime zone law, and we have a very abbreviated definition of maritime zones. So what is the meaning of maritime zone? Is it by virtue of our existing constitutional precept of our territory coming from the Treaty of Paris? Is it based on UNCLOS? Is it based on the just cited arbitral ruling? Or is it a combination of all? Because our Constitution, and even the deliberations during the Constitutional Commission made mention, and I made mention of not just, and this is cited by the case of Magallona versus Ermita. The definition, the deletion of the words historic right or legal title should not be interpreted as precluding future claims over which the Philippines does not actually exercise sovereignty. So, baka po may mga pagkakataon pa na lumaki pa ho yung ating teritoryo. So kung nilagay na natin dito sa maritime zone na ito lang yung ating teritoryo, eh baka sumalungat naman tayo dito sa Magallona versus Ermita na sinasabi that it should not preclude us from actually exercising future claims. Balay nyo, balang araw, mas malakas yung sandatahang lakas natin. Tayo na yun ang babangga. Baka mas marami na tayong mapuntahang territory. I'm not referring to a claim somewhere in the south which might arouse different interpretations, pero Magallona versus Ermita decided by the Supreme Court is very clear. It should not preclude us from exercising future claims to areas over which the Philippines does not actually, and that would mean the present situation, does not actually exercise sovereignty. Professor Batumbakal?
Yes, Mr. Chair, you're correct. That's why it's always been a dilemma of balancing, shall we say, the wording. As currently worded, Section 2 is very general, yes. That might be a disadvantage to some in that it doesn't specify, and there would be doubts as to where it applies to. But then, on the other hand, it can also be interpreted to apply at any time now, because when you say the maritime zones of the Philippines, there is no specification of what that word the Philippines actually covers. So that can be used, for example, to refer to the Philippines as it exists now, or the Philippines as it exists in the future, like 50 years later, if any configuration has changed, it would still be applicable.
Po tinanong yan kasi si Attorney Gatchoon kanina ay binanggit at laging binabanggit yung pangalan ng yung title ng case dun sa arbitral ruling. So yung sa arbitral ruling sinabi ito yung atin. Subalit itong ating Supreme Court sinasabi ito Magallona versus Ermita, ito pa yung pwedeng maging atin. And yet, we are not mentioning the Philippine Supreme Court in our measure. Hindi natin binabanggit yung whatever the court will decide pursuant to the Magallona versus Ermita. So, nakatali tayo doon sa arbitral ruling. Ito yung sinabi ng International Court, pero yung ating sariling kataas-tasang hukuman, sinasabi, pwede pa pala tayong lumaki. Pwede pa lumaki yung Pilipinas, di ba? How do you reconcile the two? The arbitral ruling as well as the, if this is an obiter, the pronouncement coming from Magallona versus Ermita, that perhaps in the future, sinabi ni Attorney Batumbakal, 50 years from now, baka tayo pa lumaki. Baka may mapuntahan pa tayong iba. I'm sorry, Professor K. I'm speaking in our language. What I'm saying is this: we're trying to reconcile the arbitral ruling as well as a decision coming from the Philippine Supreme Court, which recognizes that perhaps in the future the Philippines can actually exercise claim and jurisdiction over areas not being claimed right now. So it's part of decisions of the Philippine Supreme Court would form part of the laws of our land. So there is a need to reconcile this, and I leave it. I will. That's the reason why I'm asking our experts here in front of me. Again, Professor Batumbakal, you have the floor.
Thank you, Mr. Chair. Well, basically, we just need to make a kind of decision whether the verbal formula that we will use basically is one that is open to interpretation even decades from now and would still be applicable to the situation decades from now, or if we want a verbal formulation which is specific and using only using contemporary references. So I think this is something that we will have to defer to the wisdom of the Congress about. But for me personally, my preference would be for more general wording, so that no matter what kind of changes there are, they can still be covered, no, the Section 2 will still apply to them regardless.
So you're not espousing the mention of the arbitral ruling. You're not supporting the proposition that the UNCLOS should likewise be mentioned in Section 2, as well as reference to the normal baselines that would probably include the Kalayaan Island Group as well as Baho de Masinloc.
Well,
Diyan natin yun.
Well, not in this specific provision, Your Honor, because if it's in this provision, then the other provisions will also need to reflect the same kind of formula. Mention of those matters can be better off in a separate provision, a general provision, like as it exists, similar to what exists now in the current version, where it's a separate section 10. That way, it's there. It can apply to all the preceding sections, and at the same time, if later on things change, it can be separable. No? Subsequent legislation perhaps can adjust it simply by referring to that specific provision. No? But at least we don't need to amend each and every one of the other provisions of the law.
So what you're saying, Professor, is that a separate provision after Section 10, which would make mention of the archipelagic baselines under RA 9522, as well as, what about, diretsuhin ko na to para maliwanag. Kailangan ba natin banggitin dito yung Baho de Masinloc at yung Kalayaan Island Group? Yun na yun. Hindi na tayo magpapalihis-lihis.
In Section 2, Your Honor?
Another section, as what you insinuated.
Well, it would simply reiterate RA 9522, and it would be a clarification that we are applying the maritime zones to those areas as well. So I think it would help. At the very least, it will eliminate any potential ambiguities. The other way that can be tackled, however, Your Honor, no, assuming we don't put it here, no, the other way it can be tackled is through implementing rules and regulations, actual executive action, because that would still be part of the law anyway. No? So even if we don't mention, even if the law is very general, no, in its wordings and descriptions, it will be the executive which will now bridge the gap between the law and reality through implementing rules.
There were abuses in the utilization of the IRRs. Sometimes the IRRs would not jive with the law.
True.
Sometimes the IRR can be considered as administrative legislation. So if there is a chance of having that placed here, would it be wrong?
I do not believe it would be wrong, Your Honor.
Would it be contrary to the arbitral ruling?
No, Your Honor, because RA 9522 simply enacts archipelagic baselines and then describes the separate island territories of the Philippines as being subject to normal baselines. And that's exactly what the arbitral ruling actually supports.
Would it be contrary to our Constitution because of the deletion of the words historic rights or legal title?
Well, historic rights and legal title no longer appears in the current formulation, Your Honor. So I don't think it will be a violation.
Would it conform to Magallona versus Ermita?
Yes, Your Honor, because Magallona versus Ermita simply validates the enactment of RA 9522.
So sa palagay niyo po, Attorney Batumbakal, maggawa tayo ng isang section na nakalagay na po yung Kalayaan Island Group at Baho de Masinloc.
Pwede po.
Scarborough Shoal, Panatag.
Pwede po.
So that would be after Section 10.
Pwede po. I can imagine it's something like an area of application or, well, it can actually be incorporated into the current version of Section 10. No?
Do we limit it to Kalayaan Island Group and Baho de Masinloc o baka hanggang saan pa tayo?
Well, sa ngayon
pa tayo?
Sa ngayon po, Your Honor, yun lang naman yung other areas outside of the main archipelago that we have sovereignty over. Wala namang ibang isla anywhere in between.
Sigurado tayo doon?
Papa.
Yung Subi? Subi Reef.
Subi po is within the Calayan Island Group.
Hindi ba natin i-mention yun?
Hindi po kailangan
Hindi
dito.
na kailangan. Pero do we
Kasi nga po, this law is more
possession
general.
of Subi? Who has possession of Subi?
China currently occupies Subi Reef, which is unfortunate for us. No?
So you are in agreement that we have another section that would make mention of the Scarborough Shoal as well as the Calayan Island Group.
Yes, Your Honor. It can be a clarificatory kind of provision.
Thank you, Professor. You've heard us, Professor K. We cannot hear you. Please unmute.
Yes, Senator. I've listened to the discussion with interest. I must confess, aspects of it in terms of the Philippines domestic law are outside my expertise. I don't have a significant problem with Section 2 as it proceeds in the draft at present. I think it introduces the subject matter very well. When I expressed concern some weeks ago at the initial hearing that I was invited to, my concern was to ensure that the baselines generated by Philippine territory outside of the Philippines archipelagic baselines were consistent with international law. And at the moment, Section 3 in Section 4, rather, I should say, Part B, refers to baselines outside of the archipelagic baselines drawn in accordance with Article 8. Article 8 limits you only to straight baselines pursuant to Article 7, whereas other forms of territorial sea baseline, particularly those under Article 6 that can apply to reef.
Professor, where are you now? You're in Section 6 or?
Section 4.
Section 4. Before we proceed with that, are we all in agreement as to the implications of Line 2? All territories of the Philippines shall generate the respective maritime zones in accordance with international law. I'm referring now to the definition of territory.
Yeah. I have no difficulty with Section 2 as it presently is
The
drafted.
second sentence, I'm referring to the second sentence. All territories of the Philippines shall generate the respective maritime zones.
Yeah, no problem with that as it presently stands at all.
Professor Batumbakal, no controversial implication?
No, Your Honor. In fact, it's a very general statement. It gives us flexibility.
Even if the territory is not right now occupied by the Philippines?
Yes, Your Honor.
They should generate their
Yes, Your Honor.
maritime zone?
Yes, Your Honor.
Even if it's occupied by another country?
Yes, Your Honor. Our only difficulty there is that because it's occupied by another country, we are unable to take the necessary step of actually measuring or determining the normal baselines, because that requires people on the ground actually doing the measurements.
But would it not give them the privilege of again exercising jurisdiction of a maritime zone in a territory supposed to be ours, occupied by them, now applying the law that we're trying to craft here?
No, Your Honor, because number one,
they will benefit.
No, Your Honor, because number one, this is our law, and they're not bound by it, basically. They don't recognize it. And in fact, they are trying to apply their own law to that area. No? So it doesn't, the fact that we enact it this way does not give them that kind of authority. They cannot invoke our law.
They cannot use this against us.
Yes, Your Honor, they cannot use this against us. Because, in fact, if they invoke our law, then that means they're recognizing our sovereignty and jurisdiction. So
correct. That's what I'm alluding to. So no problem with Section 2. Professor K, you went to Section 4. You jumped ahead. Internal waters. Nothing wrong with this.
Look, I'm sorry, Your Honour. I just note that I'm jumping on a plane in about 15 minutes, so I was doing my best to be as helpful as I could with the time remaining.
Yes, go ahead with Section 4 before we allow you to leave.
My only concern is that the reference to Article 8 of the Law of the Sea Convention unnecessarily constrains the Philippines' ability to use other forms of territorial sea baselines around territories outside of the archipelago. So, for example, if you have a feature like Scarborough that has an outer reef with land territory inside the atoll structure, you would want a baseline that was on the basis of the outer reef, which would be consistent with Article 6 of the Law of the Sea Convention. The reference to Article 8 limits you only to straight baselines in accordance with Article 7, which wouldn't be useful. You would be unnecessarily constraining your ability to do things that you are otherwise entitled to do. That was the point I was seeking to make.
I think you're correct. There should be no mention of Article 8 because that would, in effect, implicate likewise Article 7 of
That's
UNCLOS. So the straight baselines would be implicated, and perhaps this can be subjected to a variety of interpretations likewise.
Well, it could be. Article 6 is perhaps the most useful given the geography of the West Philippine Sea, in that you would have a number of features that would be surrounded by reefs, and you would want to measure your territorial sea baseline from the outer edge of those reefs to maximise your entitlements, which international law give you. So a reference to baselines that didn't allow you to make use of that would be unnecessarily wasteful of an opportunity, if I can put it that way.
So either we delete the article, the reference to Article 6, or specifically mention Article 6, delete Article 8, mention Article 6, or just drawn in accordance with the appropriate provisions of UNCLOS. Make it that general.
Yes, I think that the general approach would probably be the best. It would give you the greatest flexibility. I think really just noting the reference to Article 8 is unnecessarily constraining. The idea would be to have as great an opportunity as possible.
Thank you, Professor. I think you have another appointment. You're about to leave.
That's right, Senator. I have to jump on a plane to Yosu in South Korea. So I'm terribly sorry I can't be of greater assistance. But
you've been of great assistance. You've been of great assistance. The committee will give you an appropriate certificate of appreciation.
Well, thank you very much, Your Honour. It's been a delight to assist, and I wish you and your colleagues every success.
Thank you, Professor. Professor Batubakal, any response concerning the deletion of Article 8 and placing in lieu of Article 8 appropriate provisions of UNCLOS?
That is fine with me, Your Honor. It does give us more flexibility, as Stuart has noted.
Thank you. Solicitor General, any response concerning this? Matatapos natin to.
Mr. Chairman, we submitted the OSG's position paper today.
Yes.
And
bibigay lang sa akin.
right, and we presented various options depending on the exigency of or the need for the immediate passage of the Maritime Zones Bill. So if there is some sense of urgency to enact this law or this bill into law right away, then probably we can stick to the general formulation of the various bills. They're general enough, and my understanding is that they're practically lifted from the counterpart provisions of the UNCLOS with respect to the definition of the maritime zones. Now, we can probably, we presented certain options actually, Mr. Chairman, and one of this, in our basic position paper, we mentioned that there are two significant matters that could probably be included in the Maritime Zones Bill. And that is, number one, on the Eastern Front, the matter of the Philippine rice. The grant of by the Convention on the Extension of the Continental Shelf, or rather on the Extended Continental Shelf, be mentioned because that's a very significant development in our eastern front, the eastern side. And on the western side, the arbitral award of July 2016 is something worth mentioning. So it all depends, Your Honor, on whether we need to pass this law immediately. Because if that is the case, then we can probably stick to the general formulation of most of these bills. But if time would permit, then we would suggest certain other inclusions in these proposed bills. For example, we can, as I mentioned, these two major developments is one other possible option. Another option would be to make reference to the actual existing bills, laws that pertain to our rights and obligations on various maritime zones, like on the territorial sea, on the EEZ, etc., being incorporated in these bills. So the whole problem with that, Mr. Senator, is that will probably take a lot more time in enacting this bill if we will incorporate the relevant provisions of other existing laws. So what we're trying to do, in effect, is to update and codify all the rights and obligations pertaining to our maritime zones. So it really depends on what Congress intends to do. If Congress wants to come up with this law immediately because of current circumstances, then I guess in general, the present formulation would be sufficient. But if time would allow, then we would have wanted the inclusion of certain other.
Is your son Thatcher?
Sorry.
Can we unmute? Technical, we have a challenge interference. Radio challenge. Go ahead, Soljan.
Well, that's about it, Mr. Chair. We're just presenting certain options. But if you're minded to, in general, adopt the more or less uniform presentation of the bills by the various proponents, then we have no further anything to add, nothing further to add, except on the matter of the west of the Benham Rise and the arbitral ruling with respect to our neighbor.
I totally agree, Soljan, that Benham rice or the Philippine rice should be included, and I think this is really very relevant insofar as the Pacific side is concerned, and the utilization of marine research and the identification of the underwater sea features, which NAMRIA, without the knowledge of Congress, did unilaterally. Alam nyo, sinasabi ng ibang mga kasama ko sa Senado, yung pagpapangalan nga ng kalye, inaaprubahan pa ng Senado. Nangyari dito, inaprubahan na, nakikinig ang NAMRIA ngayon. Ginawa na ng NAMRIA ng mga pangalan kung ano-ano yung mga hundreds of underwater features sa Benham Rise. So, it should likewise be part of the measure. Tama po yun, Soljan, and I was browsing at your position paper. You made reference to the fisheries decree, fisheries code, the NIPAs include. Siguro po, general reference to existing laws can be inserted in the bill under consideration, Section 10, or even in the Section 10, adherence to existing laws. So we totally agree. One last controversial item that probably would need the convergence of minds here is with reference to the exclusive economic zone. Exclusive economic zone, Section 8, the exclusive economic zone of the Philippines refers to the waters beyond and adjacent. This is an UNCLOS definition, and then mention was made of Presidential Decree 1599, otherwise known as the Philippine Exclusive Economic Zone of 1978, but this was prior to UNCLOS. This was prior to UNCLOS 3, 1978. So Is there really a need to make mention of the 1978 law? I'm referring to Section 8. Siguro pwede nang alisin yun. Valid pa ba itong Philippine Exclusive Economic Zone of 1978? Is this still a good law? This probably might be a presidential decree overtaken by events. Any Department of Justice? Bakit hindi na lang ito yung amend natin? Yung Philippine Exclusive Economic Zone of 1978. Is this still a good law?
Yes,
Wala pang unclose nun eh.
yes, that's correct, Mr. Chair. This is a 1978 issuance, and it predated the 1982 UNCLOS. But the advantage, Mr. Chair, of not totally repealing Presidential Decree 1599 is to show to the world that we have actually expressly claimed our EEC way back in 1978, because under UNCLOS, you don't automatically have an exclusive economic zone. Unlike the territorial sea, which is automatic to you, we just need to declare its extent. With respect to the continental shelf is also automatic. With respect to the EEC and the contiguous zone, you need to expressly declare and claim that you have an EEZ and contiguous zone. So the advantage of mentioning this law is an acknowledgement that we have declared our EEC way back in 1978. The provisions of PD 1599, some of the provisions continue to be good law because it's based on the provisions of the UNCLOS. But there's some provisions there that are outdated already. Like, for example, it's Section 5 that provides for the imposition of the penalty of imprisonment in case of violation of our rights in the exclusive economic zone. This would already run counter to Article 73 of UNCLOS, which provides that the violation of our fisheries laws in the exclusive economic zone cannot be punished by imprisonment. We can only impose fine. But anyway, that particular Section 5 has already been considered amended by our fisheries code, which actually provide very high fines in millions of pesos with respect to poaching by foreign vessels in our exclusive economic zone. And I just would like to connect this because in our position paper, in our study, Mr. Chair, you would receive it, we are actually proposing an inclusion of a section on implementing rules and regulation. But we took note of what you said, there's an abuse in the drafting of the IRR because the issuance of an IRR might actually help. We can say in this law that the concerned agencies can issue IRR, and violation of those IRR imprisonment can be imposed, for example, because in our exclusive economic zone, we have rights there, not just on fisheries. You have rights to regulate the establishment of artificial islands and installation. We have the right to regulate the conduct of marine scientific research. The concerned agencies can issue these implementing rules and regulations, and violations of those IRR can be punished by imprisonment so long as there's a provision in our bill that violation of those IRR can be punished. We consider this proposed Philippine Maritime Zones Act as actually our mini constitution on our maritime zones. If the UNCLOS is the constitution for the oceans, the Philippine Maritime Zones Act is our mini constitution for our seas. So it declares all of our maritime zones and our rights with respect to those maritime zones. The concerned agencies of the government can issue IRR to regulate the exercise of our rights in our maritime zones, Mr. Chair. So going back to PD 1599, it remains to be good law because there's an advantage in mentioning it to show to the world that we have actually expressly claimed our EEC way back in 1978. There's just a need to update some of its provisions, Mr. Chair, because the statement there on our rights are not the complete rights under UNCLOS. Thank you, Mr. Chair.
My only concern, attorney, correct me if I'm wrong, is that because this was circa 1978, this probably was made after the 1973 Constitution was promulgated. which mentioned clearly historic rights and legal title. The historic rights and legal title was deleted under the 1987 Constitution. And if we proceed further, one of the main issues ruled by the arbitral tribunal was the complete disregard of historic rights, historic fishing grounds of China in areas being claimed by China. So if we now revert back to the 1978 law, would it run in conflict with the decision in Magallona versus Ermita, as well as the arbitral ruling disregarding the notion of historic fishing rights for the arbitral ruling, historic rights for the under 1987 Constitution? Will it conflict with our agreed upon previous provisions that we stick to the present legal regime? Baka naman tayo magkabulol-bulol na tayo rito. Dito, sabi nyo sa China, wala kayong historic fishing rights. Tapos ngayon, tayo naman, dito sa exclusive economic zone natin, ang basehan nito, yung historic rights din natin. Hindi kaya magkawindang-windang tayo rito?
That is correct. Your statement about historic rights, Mr. Chair. No, the arbitral award has ruled that China has no historic rights in our exclusive economic zone. The basis of our rights in our exclusive economic zone is not historic rights, but sovereign right, Mr. Chair. When we issued this 1978 presidential decree, the negotiations for UNCLOS were already underway at that time. UNCLOS the negotiations were concluded in 1982. It took about 10 years to conclude the negotiations. So in 1978, when we issued this law, we already have an idea of the language to use for the declaration of our exclusive economic zone. And the basis of the establishment and declaration of our exclusive economic zone is not based on historic rights, but based on sovereign rights, Mr. Chair. And that's also what is provided right now in the 1982 UNCLOS. Sovereign rights po yung basis ng EEC natin.
What
and
about
not
the
historic
1978
rights.
exclusive economic zone law?
Ito po, yung exclusive economic zone law natin is not based on historic right, but sovereign right.
Conditions, ano exact words?
Sa law po, I don't have, but we can
Yes,
check
I think
right
you should take a look at that because connected yan sa 1973 Constitution. Solicitor General, any word on this? Kasi kung ilalagay natin itong Presidential Decree 1599, I agree it would show historical roots, but then again, it might run counter with existing
I don't
legal
think so,
precepts.
Mr. Chair. I think Presidential Decree number 1599 was mentioned in this paragraph only in relation to the previous part of the sentence where the exclusive economic zone was determined to be up to the extent of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, comma, as established by Presidential Decree number 1599. So the mention of PD number 1599 was only for the purpose of restating the basis for the 200 nautical miles measurement of the exclusive economic zone and for no other purpose.
Thank you. Likewise, we probably would be asking a one-pager from the Department of Justice, consistent with my previous questions a while ago. So, any issues concerning the exclusive economic zone, sovereign rights for purposes of exploiting, exploring, conserving natural resources, etc., the seabed, which the DFA just entered into a treaty, the economic zone, artificial islands. Should there be a mention of islands, artificial islands, within our exclusive economic zone, constructed by another occupier? What happens to those islands? Silent na lang tayo? Atin yung lugar, may gumawa ng artificial island. Pagkatapos, ano na mangyayari daw? How do we treat them? How should the new law treat those islands? Under lease, under usufruct, ano yon? Ano mangyayari doon? Under tolerance, in perpetuity, being used by another tenant without paying rent. DOJ.
Thank you, Mr. Chair. I just checked the PD 59. We will submit in addition in our position paper. But Mr. Chair, with respect to artificial islands, the language of our bill, pending bills, Mr. Chair, in Section 8, is taken from UNCLOS itself, lifted po siya. It's lifted from UNCLOS, and one of our rights in the exclusive economic zone is the exclusive right to construct or regulate the construction of artificial islands, installations, and other structures. Yes, so
The artificial islands should be constructed by the state which has the sovereign right to construct. But in our case, there were artificial islands constructed by another state. What happens now to those islands?
Those
It's not
islands.
part of UNCLOS. It's not part of UNCLOS. Probably this is now the time you define your countermeasure.
Yes, those islands are illegally occupied, Mr. Chair, and that
Occupied or illegally constructed?
illegally occupied, and the artificial island is illegally constructed, Mr. Chair.
How do we address this situation? How should we define them?
Yes, there is a continuing violation of our rights in the exclusive economic zone. And you're right, Mr. Chair, there's a need for a countermeasure, maybe. Yeah, because there's a continuing violation, Mr. Chair. That is a fact. No? Everybody knows that our neighbor has 7 artificial islands in our exclusive economic zone. 2 of those.
Can you name them for the record?
Yes,
Can you name them?
Mr. Chair, the 7 artificial islands of China are placed on top of Mischief Reef, which we call locally as Panganiban Reef, Subi Reef, which we call locally as Samora Reef, Johnson Reef, which we call as Mabini Reef, Gavin Reef, which we call as Burgos Reef. So that's 4 already. Quarteron Reef, which we call as Calderon Reef, Fiery Cross Reef, which we call as Kagitingan Reef. One more, McKennan Reef and Huge Reef, which we call together, we consider them as one as Chigwa Reef. So 7, Mr. Chair. Let me just state for the record that 2 of those.
You have an A for this recitation.
Thank you, Mr. Chair. I memorized it. I'm a regular attendee of the National Task Force for the West Philippine Sea, Mr. Chair, and as an alternate representative of the DOJ. And Mr. Chair, let me just state for the record that out of the 5 artificial islands illegally occupied by China, 2 of those islands are low tide elevations. In particular, Mischief Reef and Subi Reef. Mischief Reef is just about 125 nautical miles from Palawan. Since it is a low tide elevation, it forms part of our EEZ and continental shelf, and it is not subject to appropriation by any state. It is not land territory that can be appropriated. So China placed a artificial island on top of it, about 550 hectares in size, and no matter how long China stays in that artificial island, million of years, no matter its occupation thereof, can never ripen into ownership because that low tide elevation is not the subject of appropriation. Mr. Chair, this is the same
That
for
is also
Subi Reef.
included in the arbitral ruling. But are you interested in having that included as a subsection in the artificial islands, which I mentioned a while ago?
No need, Mr. Chair.
No, not the complete citation of the islands, but illegally constructed islands, or would it be too aggressive on our part to mention that?
Let me just relate to what our Solicitor General, our former SOJ at the Department of Justice stated. We want to be positive in this law. This law is like our constitution, our mini constitution for the oceans. So it just enumerates our rights in our EEZ. For example, we have the sovereign rights to construct artificial islands in our EEZ. But violation of our rights, Mr. Chair, you can actually provide for penalties, Mr. Chair. But this can be done
Reparation.
in an IRR, Mr. Chair. We can issue an IRR that would regulate the construction of artificial islands in our exclusive economic zone, and violation of those rules, penalties can be imposed. So pwede po sa IRR na yon, because this is just
Would there be a difference from what you know, if an island, an artificial island is being constructed by a Filipino and a foreign, a national? Would there be a difference? Not a state party. For instance, a claimant, Filipino citizen would want to convert a reef or a shoal into an artificial island as his own, as against a national of another country. There be a difference.
Actually, if it's a foreign national, Mr. Chair, in collaboration with Filipino, foreign national.
On his own, on his own.
On its own. It's
But
actually easier to punish a foreign national than if it's a state that constructed the island, because a state would enjoy state or sovereign immunity, isn't it, Mr. Chair?
Or if it is a Filipino citizen.
Filipino citizen, more so, in violation of
Filipino citizens. 10 na sila.
Yes, all citizens, Filipino citizens
So,
are subject to our laws.
What
They
about a
can-
joint venture between a group of Filipino citizens and a group of foreign nationals constructing an artificial island somewhere out there in the West Philippine Sea for tourism purposes?
Yes, they can be punished if we provide a law for it, Mr. Chair, with punishment. These are private individuals. They don't have immunity.
State corporation.
State corporation. It depends. Yeah, it depends, Mr. Chair. But the thing is, now that we're talking about it, we actually don't have a law regulating the construction of artificial islands in our exclusive economic zone. So that is why, Mr. Chair, in our study.
With the indulgence of DOJ, is Sandra Arcamo.
I'm not a lawyer, Your Honor, but then I think they will have to undergo the environmental law on environmental impact assessment. So they still have to seek certificate to do so. So I think under the environmental law, they are bound to seek, how do you call this, a consent
From
from
the
the
DNR.
national government. Not only DNR, but other NGAs as well who are affected.
So back to the question again, would a provision germane to artificial islands, including the ownership, should it be included, or should just tumahimik na lang tayo?
Because, Mr. Chair, it says here, Section 8B, we have the exclusive jurisdiction with regard to the establishment and use of artificial islands, installation, and structures. So if you have this general language, it means that any state that establishes an island there without our consent is violating our sovereign rights, Mr. Chair. So there's no need to also include a paragraph here on illegal construction, Mr. Chair.
Solicitor General.
Yes, Mr.
Our inputs. But
The contiguous zone, the exclusive economic zone, as mentioned in Article 47, and NAMRIA should really be part of this group. We are not sidelining you. You will form part of the whatever would be the product and output of this committee. We recognize your good work so far, things you've done, and we hope to be continuously engaging with NAMRIA And I supported even your budget during that budget hearing of DNR. So again, relay to your good secretary our best wishes. So Namria, if you have a position paper to submit, kung gusto mong isekreto na lang, isil, o lagyan ng napakaraming stapler, you submit this to this committee. And for the record, may we hear something from Namria before we end?
Thank you very much, Mr. Chairman. Yeah, we have our position paper and I'll submit it afterwards. And if I may just read it.
Go ahead, sir.
The National Mapping and Resource Information Authority fully supports the various maritime Senate bills defining the maritime zones of the Philippines in accordance with the provisions of the United Nations Convention on the Law of the Sea. As the central mapping agency of the government, the NAMRIA needs a definitive legal basis for drawing the outer limits of our maritime zones. While we have Republic Act number 9522 establishing the archipelagic baselines of the main archipelago and treating the Kalayaan Island Group and Bao de Masinloc under the regime of islands consistent with Article 121 of UNCLOS, we still have to deal with the existing provision of Republic Act number 3046 on the territorial sea and internal waters of the main archipelago and the need for a clear basis and delineating the contiguous zone. We are grateful to this committee and the authors of the bills for recognizing the urgency of enacting the Maritime Zones Bill in the light of pressing developments in our maritime fronts. We therefore join our colleagues in the executive branch in supporting this vital piece of legislation. We fully agree with the provisions defining the different maritime zones and the sovereignty, sovereign rights, and jurisdiction that we exercise over them. We welcome the provision on delimitation in cases where these zones overlap with those of neighboring states, as this will facilitate our work and delimiting the common boundaries. Thank you very much, Your Honor, Mr. Chairman.
Salamat po, Namria. Again, thank you for your participation. We expect your position paper likewise. At kung meron kang sealed communication that you would like to submit to this committee, we will gladly accept. And as I've mentioned to the DFA representative, she will go to heaven. You will be beatified for helping this committee. Without objections on the part of my other colleagues, some of whom are listening virtually, I'd like to thank all of the resource persons who helped this committee and this special Senate Committee on Maritime Admiralty Zones hearing is hereby adjourned. Thank you. Meron ganun eh. So, doon muna tayo. Doon muna tayo tapusin yung investigasyon. But just the same, I'd like to commend the Philippine Coast Guard for being steadfast. Talagang sinasadya na yun. Hindi naman pwedeng dalawang insidente sa minor collision sa isang araw.
Can we hold them accountable under our domestic laws?
Yung damage doon sa barko, sa yun na May 2, Inaiza May 2. So yung sira doon sa barko, yun pwedeng maging liable sila doon, plus the civil damages that can probably be secured by the crew, yung stress, yung psychological difficulties during that moment na binangga sila. So, yun siguro. They can file a case.
Pero as far as you know, sir, as a lawyer, wala po ba silang sovereign immunity?
Militia yun eh. Kine-claim nilang militia yun eh. Kine-claim nilang commercial fishing vessels yun eh. Diba?
So, hindi sila sakop ng
Hindi.
sovereign immunity?
Kine-claim nila na privado yan eh.
Yung ba't yung CCG vessel?
Ayun, medyo iba yun. Oo. Dalawang incidents kasi yan eh. So, hintayin lang natin siguro kung ano yung gagawin ng Pangulo. Suportahan natin yon. At natatandaan niyo ba yung sinabi ko dati? Nakalimutan niyo na. Yung don't spoil our Christmas. So, thank you.
Anong meron, sir?
Tuloy yun na. Hindi na, si Gina Jane na. Ay, kinig na lang ako. Hindi latest. Wala naman eh. Wala naman. So, bago na yung...
Sinabi ko yung kanina na pwede naman arestuhin yung naroon, but hindi yun yung priority. Parang yun yung pagkakasabi nyo kanina, so pwede ipakita.
Well, as far as the mandate of the Philippine Coast Guard is concerned, of course, we can carry out maritime law enforcement. In particular, yung pag-counter nga ng IUUF, that was the question this morning. However, I mentioned, I highlighted the fact that during the resupply operation, our mission objective is to support the armed forces of the Philippines in completing its resupply operation. Secondly, I also mentioned the proportionality of the vessels. No? There were 16 Chinese maritime militia vessels, and there were 5 China Coast Guard vessels. And of course, we also mentioned the presence of 2 PLA Navy vessels. Kung gugustuhin nga ng Coast Guard na mag-carry out ng boarding sa mga Chinese maritime militia, of course, by mandate, we can do that. But again, in terms of proportionality and our priority during that time, that is to complete the resupply operation, kaya we never did such a maritime law enforcement function.
Sir, ano ba lang, na kapag ginawa yung boarding, possible na mas ano yung tension o ano ba?
Well, we can expect that, no? I mean, with the videos that we released, the Chinese maritime militia vessels are even bigger than the 44-meter Philippine Coast Guard vessel that we deployed.
Do you expect, since this happened yesterday, do you expect na mas maging aggressive and hostile ang CG after the Chinese Coast Guard after this?
If we're going to look at how the Chinese Coast Guard and the Chinese Maritime Militia respond every time na merong masyadong grabing aggressive action na ginawa ang Chinese Coast Guard or Chinese Maritime Militia, ang ginagawa nila, and then we publicized it, the following resupply, hindi naman sila ganun ka-agresibo. Well, of course, it's the international community criticizing and condemning their aggressive behavior. That's why we can also expect that they are going to tone down yung magiging approach nila sa mga susunod na panahon. However, on the part of the Philippine Coast Guard and the Armed Forces of the Philippines, we are always expecting that the level of aggressiveness will still be the same.
And this will not be the end of what they're doing with the West Philippines.
If you can speak for them that it won't be an end for them, definitely that will not also be an end for the Philippine Coast Guard and the Armed Forces of the Philippines to prevent us in continuing our resupply operation.
Sir, are there going to be changes sa RORE mission strategy natin without divulging details because of what happened?
Well, I think the Armed Forces of the Philippines and the Philippine Coast Guard, together with our President already and our Secretary of National Defense, they had a meeting this morning, and those operational details were already discussed. I do not have any authority to disclose it to the public, but definitely there are contingencies that are being planned out right now. Yes, embedding our media friends has always been the priority of our national government. President Bongbong Marcos believes that our transparency initiative is very helpful in telling not just the Filipino people to be aware of what is happening in the West Philippine Sea, but also for us to garner support from the international community.
Sir, in yesterday's incident, meron po bang kasama local media?
Yes, there were embedded media from ABS-CBN, si Bianca, from GMA, Ms. Sandra Aguinaldo, and from PTB4, si Gio. And the local media from Palawan.
Sir, yung nangyari kahapon?
TV5.
Sir, yung nangyari kahapon, ang basa niyo po ba ay intentional, sinasabi intentional, o resulta lang po ng dangerous maneuvers yan? Ano po? Is it intentional kapag yung maneuvers mo, ganun, parang nangigitik?
As what we have presented this morning, no, together with the Armed Forces of the Philippines, the Department of Foreign Affairs, and the National Security Council, we mentioned that there is a collision incident. As to whether it is intentional or not, we go back to the behavior of China, highlighting the fact that I would always tell this to the public, that the only reason why there are a lot of news that is being publicized in the past months since we started the transparency initiative last February, it's because the national government is allowing the public to be aware of what's happening.
So, meaning may dati pang mas malala doon?
I cannot speak for the previous incidents, but what I'm saying is that there were reported incidents as numerous as now because we are telling the public what is happening.
Before ba hindi?
I was not the spokesperson then, ma'am.
Pero you're part of the PCG even before. So
Yes, ma'am, but I was doing my PhD for 4 years before going back here in the Philippines. So definitely, ma'am, I'm not around.
you're saying na hindi, walang escalation even if meron ng collision, actual collision.
What I'm saying is that there are incidents that are happening, but I don't want to say that there is an escalation.
So how can we frame or how can we call this? No escalation, so de facto as it is?
There is no escalation, but as what I mentioned, there is a collision because of the aggressive behavior and dangerous maneuver of Chinese Coast Guard and the Chinese Maritime Militia.
So previously we were blinded, we were not told about what is happening before, and now we are now seeing or we are now hearing what is now going on.
As I said, sir, I cannot speak for the previous government. What is the take and strategy in the information dissemination?
Well, you cannot speak for the previous administration, but you can speak as a Filipino. You are still part of the Philippines.
As a Filipino and as a proud member of the Philippine Coast Guard, I believe that the Transparency Initiative headed by our President in exposing aggressive behavior of China is the best way for us to counter the gray zone in the West Philippine Sea.
Okay?
Thank you, sir.
Maraming salamat, sir.
Yung mga hindi natin na-mention ngayon, ipapasa na or
Okay, so yun mga kaibigan, napanood natin, narinig natin yung ginawang pagdinig ng Senado dyan sa problema, dyan sa may West Philippine Sea, no? Tama naman yung sinabi, no, sa Coast Guard na dapat aware tayong mga Pilipino, no, kung ano nangyayari dito sa ating bansa. So, dati kasi, wala tayong alam, etc. Maging sa PagAsa noon, di ba? Sa bagay, on that time, ay wala pa naman social media, hindi katulad ngayon na talaga namang kahit saan mapapanood na natin, malalaman na natin ang mga nangyayari sa ating kapaligiran. So well, sana siguro kahit lahat ng Pilipino, lalo na yung mga nasa gobyerno, pinapanalangin na maging maayos itong problema dyan po sa may West Philippine Sea, na huwag sanang humantong sa hindi maganda dahil sa bagay hindi natin mapipigilan dahil kung yun ang nakatadhana, kung yun ang nakalagay, sinasabi nila sa propesiya, mangyayari ho at magaganap. Pero siyempre, hanggat maaari, huwag sana, kaya nga nandyan po ang katulad ng HWPL, di ba? Yung para sa world peace. Kaso, pag tinadhana, wala ho tayong magagawa. Kahit na sabi natin bumalik pa si General MacArthur, bumalik pa kung sino man dyan, Andres Bonifacio, wala na ho tayong magagawa dahil yun na ho ang tinadhana. Okay mga kaibigan, sa oras na alas 9:35 po ng gabi Philippine Standard Time, ay pansamantala po tayo po magpapaalam muna at magbabalik tayo bukas sa ating Wednesday edition ng programa pa rin nating Tropa. At siyempre po sa Webes, ang ating online na ranista. At sa linggo po, siyempre po yung ating One Gun Pilipinas. Muli po, maraming salamat sa lahat po na sumubaybay. No? Sila Ma'am Merle Orejenes, Mark Castro, nakita ko sa monitor ko. At sila pa rin Bayan Jogrades, ay maraming salamat. At ako po yung naging kasama, ROCEL Lopez. Magandang gabi Pilipinas at mapayapang magdamag. Magandang gabi po.
Responsable ka ng gun owner? At mahaba ba ang iyong pasensya? At hindi ba initin ang iyong ulo? Alam mo rin ba ang batas hinggil sa pag-iingat ng baril o firearms? Kung hindi,
a responsible gun owner? Are you a responsible gun owner?
Are you a responsible gun owner?
Are you a responsible gun owner?
Are you a responsible gun owner?
Are you a responsible gun owner? The PNP Civil Security Group would like to advise all firearms holders to renew their license to own and possess firearms and firearms registration within 6 months before its expiry date. Tumawag na at makipag-ugnayan.
Be a responsible gun owner.
One Gun Pilipinas ang sagot mga katropa at kaganos. Tayo ituturo sa inyo ng One Gun Pilipinas o OGP ang lahat ng legal na paraan at proseso upang ikaw ay maging isang responsableng gun owners. Ano pa hinihintay nyo mga kagamers? Sali na sa One Gun Pilipinas ngayon na! Barangay, pangunahing unit ng pamahalang lokal kung saan dito pinag-uusapan ang bawat sinalog ng mga residente ng bawat barangay. Dito rin pinag-uusapan ng mga piling halal na opisyal na barangay ang mga proyekto para sa kanilang barangay. Kumustahin natin ang panunungkulan ni Kapitan dito sa Dalo Barangay sa Millennial Online TV Worldwide, ang katropa ng bawat barangay.
Ating tinatapos ang ating pagpupulong. Maraming salamat po sa inyong pagdalo at tapos na po ang ating session. Enjoy na po tayo.
Hanap mo ba ay Unwind Ventures? Tara nang mamangha sa mga tanawin. Ano man ang iyong travel goals? Dadalhin namin kayo. Sa Unwind Ventures at saya. Dito lang sa Wow Biyahe. Kaya wow, di ba?
Abangan dito lang sa Millennial Online TV.
Now, we are
Talakayin. Biggest destruction of dangerous drugs
Rebisahin, opinyon, malawaking, aksyonan. Kasama si ROCEL LOPEZ, ang inyong katropa sa pagbabalita. Dito lang sa Millennial Online TV. Tutok na mga katropa!
Pinaigting, pinalakas, ang bagong news online TV ng bagong milenyo. Millennial Online TV, ang katropa mo sa pagbabalita.
Hi, this is Hilary Gadon. Nananawagan ako sa ating mga katropa, no? At mga kaibigan, mga kababayan, na palaging tumutok sa Millennial Online TV. At yan ay pinangunahan at yan ay pinangangasiwaan ng aking kaibigan na si ROCEL. At ang mga nanunood dyan ay hindi bobo!
Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang magiliw, ewas ang sinakalan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, kuya ka ng magiting, sa mandulupin, di ka pasisigil, sa nagtatagputok sa simoy at sa langit ang bagaw, ay hinatang tula, kawin sa pagkayang minamahal. Ang isang lang matawad mo'y tagumpay na nag-iindig, ang bituin at araw niya kailan ang may liwatitigig. Luman ang araw ng walhagit pagsinta, buhay langit sa piling mo. Ang inigaya na pagkay mga akin, at mamatay ng dahil sa'yo.
Sa lahat ng bumubuo ng Millennial Online TV at sa lahat po ng sumusuporta, maraming salamat po. Millennial Online TV is now signing off.